Okay, so good morning. How is everybody? Good. Awake? Everybody had coffee? Good. I'm Traci Tetrick, and I have come to the Indiana Department of Education by way of formerly being a classroom teacher. I was an elementary teacher for about 7 years and a gen ed teacher. Then I decided that I wanted to try something different. I went to law school. And while I was in law school, I took every education law class that was offered and made some up on my own doing an independent study. So I learned a lot about special education, because what you learn at law school is education law is actually special education law for the most part. So became intimately familiar with the Individuals with Disabilities Education Act and Article 7. So moving on to that, Article 7 is in the Indiana Administrative Code. That is where you find our rules. That is the Article 7 we refer to comes out of there. A lot of people don't know where that is, but it's actually the Indiana Administrative Code. And that's our special education rules. It is important to understand as a baseline that Article 7 applies to charter schools. You all probably know that because you're here today, but I do talk to a number of folks at different charter schools that seem to think that they don't have to follow Article 7, or they can randomly pick and choose and partially follow Article 7. Well, folks, Article 7 completely and thoroughly applies to charter schools. So, most commonly when you're working with us in the due process team, it's because someone has filed a complaint, but there are actually 3 processes in our dispute resolution methodology choices that are available when a parent has a concern. There are complaints they can file, they can request a mediation, they can request a due process hearing. So, as I said, I am a complaint investigator, so when we receive a complaint, if I were assigned, you would be working with me. I also want to take just a moment, since you're out there, to introduce you to our 2 other complaint investigators. There are 3 of us at the state. So Casey Symes is one of our complaint investigators, and Veronique Briscoe-Boy. So if you, for some reason, have a complaint filed, you'll be working with one of the 3 of us. And we all have background in both education and law. So anyway, so I want to go over these processes just so you understand them. And maybe, I think a lot of times things sound scary, but they're not so scary if you understand them better. So I want to dig in just a little bit. A complaint can be filed by anyone. And here's what you need to understand. Sometimes the complaint doesn't bear any merit. They're allegations. So a lot of times a parent may be very, very mad, but not everything in the complaint necessarily is true. So at the point we get it, they're allegations. It doesn't mean you necessarily committed a violation or you're in noncompliance. They're allegations. So your job, and I'll talk about this more in depth as we go through, but your job is to, when you have a complaint, to show us through documentation that you are indeed in compliance and you have done what you're supposed to. And that's a theme I'm going to come back to today, is documentation and maintaining a well-papered file, that you're keeping track of why you're doing what you're doing. Anyway, so the complaint alleges the school is not complying with either a state or federal special education requirement. Perhaps it alleges you're not complying with a signed mediation agreement or resolution agreement, or if there's been a due process hearing, you're not complying with the orders from the hearing officer. You can have what we most commonly have would be just one student. A parent of one student files a complaint for that student, but sometimes we have systemic complaints. And for whatever reason, we tend to get more systemic complaints with charter schools than we do with public schools. And a systemic means the school just really is not doing this right with any of the special ed students. And it doesn't have to be a parent that files it. Sometimes it is it's another family member. Sometimes it could be a friend of a student. It could be a disgruntled paraprofessional that you had to let go, and they're going to file that complaint because they have the dirt on you. So, regardless of how it comes in, we go ahead and investigate the complaint. How the complaint process works. We get a complaint the very first day. We notify the director of special ed or whoever the head of the special ed is in your school. During the first 10 days, you have an opportunity to resolve it informally. You might try to get a written agreement with the parent. You might just have a meeting with the parent and, offer some sort of resolution. Sometimes it's just a CCC meeting that needs to occur that hasn't occurred, and you all work it out, let us know, the parent lets us know, this is resolved, I'm dropping the complaint. Sometimes there's a written agreement that comes in that says in the written agreement, this agreement constitutes full resolution of all issues in complaint, whatever the complaint number is. If you don't resolve it informally within the 10 days, on the 11th day, you'll get another letter, a second letter from us, that's going to outline precisely what your issues for investigation are. Because the parent writes the complaint in parent language. Sometimes it's pretty good language and looks like Article 7, and sometimes it's written in crayon and very hard to read. So we then talk to the parent during that first 10 days and kind of figure out what's really going on, and we turn that complaint into something that's investigable under Article 7 using Article 7 language. In that letter that goes out on the 11th day, we're also going to list the type of documentation we would like you to submit in response, and we're going to give you 7 days to do that. If you provide us with the documentation that we've asked for, you're probably in compliance. So if we've listed something, provide it if you have it. Okay? Contact us if you don't understand what it is. And then after we receive all that documentation, we do issue a complaint investigation report that's going to have findings. It's going to say this is what we found happened here. And then there are going to be conclusions which are going to match up. If there's 3 issues, there's going to be 3 conclusions. Each conclusion will say either there was or there was not a violation. If there are violations, most often there is corrective action ordered. Sometimes there is not corrective action ordered. And you might think to yourself, how can we be in violation and you wouldn't order corrective action? So the corrective action does not get ordered if you have voluntarily corrected. So if you get the complaint and the very first day you get it, you say, oh my goodness, I did not realize that was occurring, and you take some corrective action, you offer some compensatory services, or for whatever you do, it fixes the problem. If the parent doesn't want to drop the complaint, even though the problem's fixed, and sometimes parents just want to play that way, we're going to go ahead and the complaint report will show that there was a violation, but there's going to be in language there. However, because the school has self-corrected, we are not going to order additional corrective action. If it's something that's if your self-corrective action is going to take you a month to do, we just may hold you to that. The school will submit documentation that completed its self-imposed corrective action by a certain date, but we may not order more corrective action. So we want you to take ownership. If a complaint identifies a problem, own it and fix it. Because ultimately that's what it's about. We want you in compliance because we want the best services possible for students. Okay, so that's kind of complaint in a nutshell. You can sometimes one of the options for that first 10 days is you agree to go to mediation with the parent. I am going to try to sell mediation to you. I'm a former mediator. And mediation is ideally suited for special education. Mediation is where you sit down, you come in as a school, the parent comes in, and you have a third-party, neutral mediator. And all of our mediators are attorneys in Indiana who are also licensed mediators. And they work with you to resolve the issue. They help you think outside the box. They may come up with solutions or propose solutions that you wouldn't have thought of on your own. Sometimes they sit you together in the same room, but if they feel like there's tension, and often there is tension because parents can often feel railroaded by the school, or like, the school never listens to me. The mediator may what we call caucus you, put you in different rooms, and they may shuttle back and forth and try to find that middle ground. But then ultimately they'll bring you back. If you reach some agreement, they'll write that up into a mediated agreement, and then that mediated agreement gets signed, and it's legally binding. If you don't reach an agreement, it's confidential and nobody knows what you proposed. So you have some freedom to propose some pretty creative solutions, and that solution is just for that one student. So we really like to use mediation. We feel like it's a great way to bring parties back together. It's the most collaborative of the 3 processes, and what we want is collaboration because your relationship with this parent is going to go on until the student exits. So we really do want to build that bridge back together, and I think that mediation is the best of the 3 processes for building that bridge and keeping that relationship in place. So we do encourage parties to go to mediation when there's a complaint. If you do mediation in conjunction with a complaint, you have 20 days to complete it, versus if you just do a standalone mediation, there are 30 days to complete it. I've talked about written agreements. If you want to resolve with a written agreement, you can either call the parent in and you can sit down with them and say, let's write up an agreement on our own. It's kind of like mediation without the mediator. Or you can propose an agreement. And that works really well sometimes too. If you call the parent and say, hey, I saw your concerns and I'm glad you raised those. And we're proposing that we do X, Y, and Z. Would you like to take a look at that? And you send them a copy of that and they see if they like it or not. And they may say, well, can you change part number 3? And well, sure I can. And then and you show that you're really willing to work with them. So you can do that. And if you don't really know how to do that, you can call any of the 3 of us, and we can give you some technical assistance in working out what a written agreement should look like. It's really pretty simple. It's just got to identify the parties and what the terms are, what you're wanting to do, and then have a place for a signature and a date. So, and if it's resolving the complaint, there's some language we can help you with that too. So please feel free to, anytime you're doing something like that, proactively call us, call one of the complaint investigators and ask for technical assistance if you need it. I talked about the complaint investigation report, and I did talk about it, but I just wanted to show you. So the report starts out by identifying the issues, and an example of that. Did the school implement the student's IEP as written? Specifically, did the school provide speech therapy as required by the IEP? And then we give the Article 7 citation. There would be findings of facts. So in this little scenario, the IEP required 20 minutes of therapy weekly. The school provided 15 minutes of weekly therapy. 15 is not 20, so they're at a deficit of 5 per week. So, conclusion, the school did not provide therapy as required and a violation of Article 7 is found. The corrective action, the school will provide compensatory therapy services. If it is very clear from the findings exactly how much you did not provide for the students, we often will order a specific number. If it's not clear, the school hasn't provided all the services they're supposed to provide, we're probably going to order you to go back to CCC, meet with the parent, and determine an amount of compensatory services that would be appropriate to make up for the lost educational opportunity for not providing those services in the first place. So, a couple different ways that might come down. So what are the common issues in charter school complaints? The single biggest issue, failing to implement the IEP as written. Often it's failing to implement the BIP, which is part of the IEP. And that's the same issue as we find in our regular non-charter schools. Failing to comply with evaluation requirements, often a timeline issue. Imposing, now this next one is more specific to charter schools. Imposing impermissible conditions on enrollment or placement processes. You can't tell students you're not going to take them. Okay? You can't say we don't want special ed students. And I don't think it would be that simple. I think it would be dressed up differently, but it boils down to that's what you're trying to do, you can't do that. So no impermissible conditions. We had a complaint with a charter school that was imposing fees that were making it really hard for some of the parents to get in there, and that's not allowable. Unilateral decision making. This also seems to be a bit more of a problem with charters than our regular schools. So what unilateral means is all by yourself. So the school is just making the decisions. They're not utilizing that CCC process that they should. And as far as I see it, discipline and manifestation determination process, that's a huge one for charter schools. I have a lot of difficulty with charters either thinking they don't have to follow all the rules for discipline, even though the rest of there's where I say only parts of Article 7 apply. No, the discipline part applies. And I've talked to a handful of directors. It's not just one. I'm not going to name any schools, but directors of charter schools who say, we run a tight ship and we don't put up with any discipline issues. And if the kids don't comply, we are not going to keep them in school. And that's just our policy. That's a great policy for your gen ed kids, but your special ed kids still get the protections related to discipline and related to manifest. So I'm sorry, you can't just get rid of your special ed kids because of discipline issues. And I'm sorry, there's another, actually from iCase recently, and this is not in the PowerPoints, this is just something that's hit my awareness since I developed these. We're getting a number of concerns from schools public schools who are telling us that when a student moves back into the public school after having been at a charter school, and the public school reaches out to do that within 10 days, asking for the records so that they can get things going, charter schools are saying, well, that student moved out, so we don't have their records any longer. How many of you think you can get rid of the records as soon as the kiddo goes? How many of you think you have to hold the records for 1 year? For 2 years? Actually, under Article 7, it requires that all the records related to special ed be maintained for at least 3. Now, there are other rules that you have to retain other things, but to be safe, at least 3 years. And that's Article 7, that's 738. 3A4 that tells you at least 3 years. So now, Indiana IEP, and Matt and I were talking about this earlier, so if you had questions, I'm getting really particular where he's going to be the expert, but you have those archived even after the student goes, so you can see everything you developed and the history the student brought with up to the time they were in your school. You're not going to be able to access that student and find out what they did in Indiana IEP after they left you, but your records are still there. So if you need help finding that, if a school reaches out to you for a former student, contact me or contact the folks at Indiana IEP and we can help you with that. Yes? And the question posed was, or the concern posed was, sometimes it's the other way around, that the public school doesn't want to give you the records. Is that correct? Yeah. So the same rule would apply to them. They don't have an IEP at all? Well, then they would need to provide you what they do have. Okay, if they've been in RTI or if they, whatever educational records they had. But all schools in Indiana, public schools, charter schools, have to maintain those records. So that's an instance where actually you raise an interesting point. Charter school, if you're asking a public school over and over and over for records, guess what you could do? Because anybody can do it, you could file a complaint. And then we could work with you to make sure that school gets those materials to you. I'm not saying to go out there and do that every time, but that would be an example of how we talked about anybody can file a complaint. So good.
Yeah, RTI and special ed, are they two different entities or are they part of the same coin?
RTI is outlined, response to intervention is outlined in Article 7, but you haven't been determined eligible if you're just receiving RTI. So if you've tried RTI, often a student who's tried RTI, the school will say, you know what, this isn't working, so now we're going to do a formal evaluation, and that's going to be what starts the process. But students who are just receiving RTI are not going to have an IEP. And if you want to contact me, I can address more of that or make sure the appropriate person addresses that later. Do you want to put that in writing? Thank you.
Do you mind one more question?
Oh, yeah, sure.
So we've had pretty good results getting IEPs transferred through Indiana IEP, but what about psych evaluations? Because their file requires that as well, and there's not the fluid system for that. So,
or because,
hold on, yeah, please repeat.
or because there's an option with the case conference committee not to do the re-eval. It's that they haven't had a re-eval for 9 years. So,
right.
They're now 15 years old, and last time they had evaluation, they were 9 or 6.
Right. Well, you would still want to ask for whatever records they have, because sometimes the absence of records is your record, right? I mean, that's what you need to know, is that doesn't exist, and then you know that you do need to go ahead and do a timely evaluation. So the school should be pushing all of that. Whatever they have should be coming to you when that student moves or when you request that. And again, if you want to talk more about records, follow up with me. Feel free to, you're going to get my email and phone number at the end. I'll be happy to address those more in depth. Okay? Thank you.
And also, if you want, so if you have a question and you want a little bit more information, if you write it down on the notepad that's there and give me your email address, we can make sure we get it straight to you that way too.
Thank you, Kristen. All right, so again, avoiding complaints. We're going to dig in a little bit here. Implement IEPs as written. Here's some helpful hints. Your teacher of record should be advising all general ed teachers in writing of the accommodations and services to be provided to students. So a lot of schools really like just giving that IEP at a glance to each of the students' gen ed teachers. So that's a great way for them to know that, and to have a folder for if your gen ed teachers have a folder for their special ed students with the IEP at a glance. That's a great way to make sure that they are in the know. So If you are sending students to a resource room, or if you're providing services in another room, and the question becomes at complaint, did you give the number of minutes you were supposed to? And you've given the number of minutes, but you've never tracked it. You're going to have issues showing you were in compliance, even if you are in compliance. So if you don't have one, develop some sort of sign-in log and have students sign in. If the student's not physically able to sign, have a parent or a teacher sign that student in, but keep track of when they're visiting the room and when they're receiving services. It can be very informal. It doesn't need to be typed up. It can look like chicken scratch. Those kind of documents are very authentic. When we get them, we say, yeah, this is the real deal. So just keep track of those services. Keep that in a file. Keep your well-papered file. All teachers should know students' accommodations and services, and again, should document the provision. Just what I just said, keep a well-papered file. We had a complaint that now has become, it was published nationally from our department. It was went out in 2014, and when you go to LRP conferences and things like that, they point to that East Allen County report that went out, that the school, and I know that director said, we did everything. And from talking to them, I really felt like they probably did, but they had no documentation of providing the accommodations for the student. So we found that they did not provide it because they could not show it, they could not prove it, and the mother was adamant that they had not received the services. So we talked about in that report, how do you document certain things, like if a student's supposed to get time and a half on a test. You don't have to document you did it every time, but at the beginning of the year when you give a test, maybe keep a copy of the test. You handwrite on the student's note for parent to see when they get it back, student provided time and a half. Okay, again, you don't have to do that every time. Make a photocopy of that and put it in your file. Okay, maybe just one round of tests you do that at the beginning of the year. It's a little extra step when you're grading, I get that. But for each of those special ed kiddos, if we get a complaint, I can say, how do we know you provide time and a half? Let me show you. Here you go. Here's a photocopy of this test. It's got legitimate, authentic student work on it. It's got your note. It occurred then, so you've documented it. That's one way.
Yeah, the kids actually sign in every single time that they come, where they're coming from, even on every test, the teachers has to attach a sheet, and so that kind of helps us to keep up with what the accommodations are, whether they can use a calculator or is it an open book, all that kind of stuff. And so I mean, I find that makes things a whole lot easier.
Absolutely, and I'm glad you said that because I'm focusing on this one. So if there are 5 accommodations being provided every time that student takes a test, it's in a small group setting with items being read aloud, except those for comprehension, calculator, whatever they are, note it on, get one test photocopied where you know all the accommodations you provided, and then you've covered yourself. Yes?
A question that I have is, if our instruction is online,
okay,
so the tests are at however long it takes a student.
Okay.
So if it takes a student 5 minutes or if it takes them an hour, how would I show time and a half?
I would communicate that to those parents whose IEP requires that they're getting time and a half. I would communicate that at least on an annual basis. It's in the IEP, they're going to get time and a half, but I would send an email or I would send something that's got a date stamp, just as a reminder. Parent of blah, 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 blah student. We allow as much time as students need on every test. Therefore, since there is no end of time, they will always be given their time and a half on all tests taken. Okay? And so if you have that email and then you put that in the file, then you can produce that. Avoiding complaints, following CCC meeting procedures. They need to be scheduled at a mutually agreed upon date, time, and place. So if your policy is you tell the parent it's going to be at X date and you don't allow their input, that's out of compliance. If the parent says they can't attend, it's not just one chance and then we do it on our own. That's unilateral decision making. You have to document the offers of other times and attempts to schedule, attempts to go to the home, attempts to do by phone. And the best way to document is to use that communication log that is in Indiana IEP. Because when I get a parent telling me that the school didn't attempt to be mutually convenient or they didn't offer other times, and I look in the communication piece under Indiana IEP, because I have access to all the IEPs in there, and I see this communication, called parent, parent didn't return call, left, attempted to go to the home. I mean, I've seen these things and I'm like, yeah, parent, sorry. The school did everything they could. So take advantage of that log in there.
You got a question?
Yep.
Quick question. So if accommodating the parent meeting time pushes you beyond the timeline, whatever you're working on, a 10-day move-in or something of that nature, how do you consider that?
Okay, I document that. So you're going to want to you want to give the parent notice. Okay, we understand that you want to meet on the 12th instead of on the 10th. We'd be happy to do so. That's going to put us beyond that. Please indicate that you're willing to go beyond that date. You know what I mean? So if the parent's okay with that, but get that in writing. Okay? I mean, and that's a hard place to be in, because I'm going to tell you, that's still going to look, if the parent really wants to enforce it, it's still going to be a technical violation. But we use that term technical violation, where, okay, technically you went beyond the 10 days, but the parent said they wanted to do that, and you were, because if you don't do that, if you say, no, we have to have it, and we've had this complaint, there's a complaint out there with this problem, then the parent's going to say, you didn't allow me to participate. This was not a mutually convenient time. So you're between a rock and a hard place. If they're really playing games, the parents that are playing games, they're gonna put you in a bad situation. So document. Because if you can say, you know what, we totally were mutually convenient. We did this at the time the parent wanted. Unfortunately, it put us 2 days beyond. But you know what, the parent signed that they were willing to go 2 days beyond. We're gonna say, that's a technical violation. You're not going to have any corrective action ordered on that one.
I believe Becky Reed sent out some guidance on that as well.
Okay, perfect. I'm sorry.
No. And I want to say, she said you meet without the parent just to make your deadline, and then you meet again with the parent. But I don't have the exact, I can look it up. Or if you want to give me your email address, or again, maybe what we could try and do is these couple of questions from today, we can just email them out to everybody that's here today, so everybody gets the answer.
And I want to reiterate, that is very good. So I want to correct what I said. So she's saying, Becky Reed is the other side, the indicator compliance. So she's saying have a quick meeting just to say that you met to meet your deadline, but your what you're basically going to do at that meeting is say, well, we met, and because parent wasn't here, we decided to reconvene. So what you do is you've checked off that you've met on your timeline, but substantively you're going to push that decision making off till that reconvene meeting. So that's a very good answer. Thank you.
I'm going to write that down right now so I don't forget to get it.
Very good. Required participants, make sure all the people that are supposed to be there are there. And I know with a charter school you've got a small staff sometimes and it's hard to do, and some people might wear multiple hats, and that's okay. But make sure all your required participants are there, including the parent. Obviously, if it's transition age student, the student can participate too. So notice, use Indiana IEP, that beautiful, wonderful notice that you can generate, and send it out. Don't just talk on the phone and say, oh yeah, we're going to have a meeting. Even if everybody's agreeing, even if the parent emailed you and told you they're showing up at the meeting and they're super excited about it and they're going to show, send the notice, okay? Because that way you've got your well-papered file. Timely evaluations. Parents' requests for evaluation may be made. See if you all are paying attention. What's the next word on my slide? Verbally or in writing. If the parent verbally asks you for an evaluation, that is a request for an evaluation. Okay? Now on our end, we're going to say to the parent, when did you make the request? And they're going to have to somehow document it. We had a former complaint investigator had a complaint filed, and the parent had a notation on her family calendar that she'd talked to the school and made a request on a certain date, and it looked legit. She photocopied that calendar page, and we're like, yeah, that looks real. It was buried in of so many things that you couldn't have added it in afterwards, and so that documented that there had been a verbal request made, and we honored that date and told the school they should have complied. Requests must be made to licensed personnel, and this includes teachers. So if you're a teacher and a parent says, I'd like my child to be tested, you need to report that up. You need to make sure whoever's in charge of special ed gets that request, because you're the person that heard it, and if you don't act, because we have some teachers, well, they just made the request, the special ed staff didn't know anything about it. Well, sorry, that works. Yes, Matt? Well, they can be excused, and yeah. So if you have a required participant who can't be there, you can excuse them ahead of time. And again, Indiana IEP has the forms to excuse the participants. Yes.
Maybe I misunderstood, but I think the question is, do they have to be there the whole time? Especially in a charter school, I've got gen ed teachers, and they can get coverage for 10 or 15 minutes, and they can come, but they're not there for the entirety of the meeting.
That's still a case where you still want that parent to sign the excusal. So here's, from a legal standpoint, so here's what would occur. So if you're there and suddenly a teacher needs to go, you can say, the parent, this teacher is asking that they be excused. I know this is short notice, but do you mind? And if they sign the consent form, then you're going to be okay. The parent does, though. It's the parent's right. Like Matt correctly identified, the parent has the option to say, no, this is an important person, and I want them here for the whole meeting. They're the person who's going to be implementing this gen ed teacher. They need to be here. So in that case, to be compliant, then you would have to say, and you would document this in probably the written notes section of the IEP, because we had a participant that had to leave and the parent wasn't willing to excuse, we are stopping the meeting and we are going to reconvene at a mutually convenient date. And then and then you do reconvene. So I assume that would be the way, yeah. You should always tell, people like to know what's going on. So laying a roadmap out and this person is going to be leaving is an ideal way to start it. Yeah, I wouldn't spring that on them midway through, just as a courtesy. Let them know up front. Okay, very good. Good questions. All right, so back to the evaluations then. We were talking about that it can be verbally or in writing, any licensed personnel. And after the parent makes the request, the school must respond within writing within 10 instructional days. You don't have to start the process within 10 days. That's kind of a myth. Some people think that. They know there's a rule about 10 days. You can say, no, we don't believe we need to evaluate this time, but that refusal needs to be in proper format. And I'm going to keep singing the same song. If you use the documentation that's in Indiana IEP, then you're going to be in compliance because that contains the necessary information, because you document why you're refusing, and it's going to prompt you to fill that in. So often, though, you're going to go ahead and say you are proposing to start the evaluation process, and in that letter that you're proposing is also the consent. So the parent's going to sign that and return that back to you, and then when you receive that consent back, that's what starts your 50-day. Okay, so it's kind of you have 10 days to respond, and then after you get the response, you have 50 days to conduct the evaluation. That's what we just went through. In addition to the evaluation, at the same time, the parent may request a meeting to have the results of the evaluation explained to them prior to the case conference committee meeting, or they can request one or both. They may request a copy of the evaluation report being provided ahead of time. Teachers, if you get an email from parent during the evaluation process saying, I want to have a copy of the report prior to the meeting, or I want to meet before we have our big meeting, I want to meet and I have some questions, communicate those to your special ed staff. A lot of issues that become complaints or problems are poor communication between staff members. So if the evaluation is going on, get something from the parent, share it, please. It'll make everyone's life easier. All right, so the other big thing is following discipline procedures. Case conference committees should be addressing behavior and discipline concerns long before we're looking at disciplinary change of placement. So if a student's having discipline issues, regardless of their area of eligibility, consider developing a BIP, doing an FBA, and developing a BIP for that student. So keep track of days of removal. I'm going to move kind of faster with this because we're going to be running out of time if I don't. Special ed students may be subject to disciplinary removals for up to 10 instructional days without services. So you get a pass. You get freebie on the first 10 days. Woohoo! All right. Half-day removals, bus removals, in-school suspensions, and calling parents to just pick up the student are considered full-day removals when counting days. I get phone calls from little Wendy Weiner. Wendy Weiner, the first-year teacher, says, I just love Johnny, and he just was having a rough day, so I just called Mom and said, why don't you just come in and pick him up? And I didn't think there was anything wrong with that. And I say, well, that's a day removal. Oh, I didn't know that. Make sure your teachers know that if They call the parent and say, there have been some issues today. We think you ought to pick up. Now, no matter how sugary sweet it is, no matter how you think you're being proactive, if you ask this parent to come pick up the student, that is a day of removal. Good question and perfect question. Which was, what if it's in the IEP and the parents has already agreed to that through the IEP? If there's a BIP, and one of the strategies is when the student's having a meltdown or when the student is doing whatever the student does, parent may be called, and this does not constitute a day of removal. Magic language, you don't count that day. But parent has to agree to it, and that has to be part of the BIP. If that language isn't in there, it's going to count as a day of removal.
And that should also be the very last resort. It shouldn't be something you throw in everybody's. It should be
that is not,
so rare that even happens or is written in.
But there are some students who really do, you know what I mean, that there are some, and this would be, let's say you've had a student who's been on a 2-hour day. I mean, they are transitioning back from maybe a home Brown placement, and everybody agrees that they might be able to do 2 hours a day, but some days you just know the student's not even going to be able to do 2 hours. That might be the student who has that language in there. It's not going to be in there forever, and this isn't a Band-Aid for all students, but that might be, that student. Her point was that students who are on medication or changing medication sometimes, maybe they would need that there too. Is that correct? Restatement of what you said?
Right, that may be an example of why you would...
when you would use that on a temporary basis. Yeah. Okay. So anyway, otherwise, generally speaking, those just picking up the student, just calling them to pick them up because it's a bad day, days of removal. So you got to count all those. Student went through the whole day, but student went out to get on the bus and punched a kid. Bus driver said, go back inside and call your parents. Even though they got through the whole instructional day because they're not riding the bus home, it's a day of removal. So you got to coordinate and communicate and keep track of those. Yes? Sending a student to the office. If you send the student to the office and they spend time in the office without services, in other words, they don't have their work with them, it's just sending them to the office, but what it really is an in-school, like an in-school suspension. It functions that way. It is a removal. They've been removed from the educational environment. They are not progressing with their peers, and they are not receiving services. So that is a day of removal. Yep, good question. Glad for that clarification. So be prepared to provide services at day 11. Remember, those 11 days are going to add up quickly when you're counting all these little removals, and conduct a manifestation determination. Here we go. Just restating. All teachers should be familiar with Rule 44. That's in Article 7, which contains the guidelines for discipline for special ed students. And discipline is more than suspension and expulsion. The American Heritage Dictionary says that discipline is training that is expected to produce a specified character or pattern of behavior, especially that which is expected to produce moral or mental improvement, or it is controlled behavior resulting from such training. So we look at discipline, we often look at the end result, but discipline should be that BIP, those strategies, what you're doing so that there aren't the discipline issues that end up with removals at the end. So kind of thinking about it broadly, and we want to be proactive versus reactive. That's a great way to think about it. That's what this says. Address behavior long before it leads to a disciplinary change of placement. If you have a special ed student exhibiting inappropriate behavior on a regular basis that's interfering with the education of that student or the other students in the classroom, consider developing an FBA and a BIP. Even if it's a speech-only student, if there's always this problem, at least do the FBA and find out what's going on. Okay? It's better to develop. Some teachers think only, ED kids get the BIP. That's not anybody. Any special ed student you can do an FBA and develop a BIP for them. Well, if a gen ed student is sometimes the discipline is the key, that there is an underlying issue and they need to be evaluated. You can informally develop a BIP, a behavior for and talk with the parents and meet with them, but they're not going to have if they're not otherwise an eligible student, they're not going to have all the protections of Article 7. But you can just use those strategies of developing what's like a BIP for a gen ed student. But my concern is if this student is having discipline issues that have risen to the level that you're wanting to develop a BIP, that might be triggering that you might need to go ahead and do. That's notice. Then the school is on notice that there could be an underlying issue that's causing that. So you might want to be considering evaluation. You might do a temporary BIP and see if it fixes it. And if it doesn't fix it, then you probably are going to be wanting to be evaluating that student because you're on note. The fact that you've developed, this is my caution, the fact that you went so far as to develop a BIP for a gen ed student, the parent could say, you had notice, you knew there was a problem, you should have evaluated. So, okay, if you cannot do if you are doing an FBA, an FBA is an evaluation.
Right.
You have to have consent
right.
to engage in actually a formal FBA.
Right.
So if you've gone that far, you can, and that's a common myth. I have a lot of, did everybody understand what she said? That administrators think they can just do an FBA and develop a BIP and they're not getting consent, and that is contrary to Article 7.
No,
if you are conducting an FBA, you have to have given that notice and received consent from the student or from the parent.
Is that the dividing factor then, basically, that a gen ed kid who's not receiving services doesn't, an FBA hasn't been done? And if they want to include an FBA, that
then
automatically
they need to get
means
consent,
that
and you need to evaluate and determine whether or not the student is eligible. That's exactly right. Yep. Yes.
So the dean of students, if the dean of students is supposed to develop FBAs or BIPs for the kids who like get sent to his office all the time, then they need to be evaluated, is what I hear you saying.
An FBA is an evaluation under Article 7, and you have to have parental consent to engage in FBA. Yes.
But if you're talking just behavior plan,
if you're just doing,
they can do that. That's different.
If you're doing an informal behavior plan, you don't.
But if it's something in writing that we want teachers to implement, then it becomes, I mean, like,
you can enter into a contract with any gen ed parent. I mean, there are times, I was a gen ed teacher, and I would have a parent come in and say, you know what, this isn't working, and we'd enter into this little thing where this student was going to have a contract, and every time they had a good day, I was going to send home, some sort of token.
Yeah.
You can do some of that, but what I'm saying is, you're getting notice then that there are issues, and if it doesn't clear, if the behavior doesn't improve with those informal measures, you're going to have a duty at some point then to evaluate that student and find out what's really going on. Entering into those informal behavior plans is notice. And if that doesn't clear it up, this parent then can say, you knew the student may have been a student with a disability because of what you did. So just use caution when you do those and be aware of that. The FBA is the process that uses data to identify patterns in the student's behavior and the purpose or function of that behavior. Why are they doing what they're doing? Parental consent is required. That should have been bold, underlined. FBA. If you do an FBA, parental consent is required. And I have schools tell me, oh, we weren't doing an FBA. We were just keeping note and keeping records and collecting little pieces of information. Folks, you're collecting data. That's an FBA. So you should have had consent. Yes?
What we want to do is an FBA, and we contact the parent. The parent says no. The behavior continues. Is there a way that the case conference committee can come back together, can look over the information and make a decision?
You're getting into a higher. Can I address that? Can you write that down, and I can address that with you? Okay. So I'm sorry. All right. The FBA, it is part of the evaluation that is required, as I think most of you know, for a student suspected of having an emotional disability. It is not required for other students, but like I said, if the students, I always use example of a speech student who's having a lot of discipline issues, then you probably need to do the FBA for them. And it's an integral part in the development of the BIP. Besides being required for a student who's suspected of having an emotional disability, FBA is also required if the student may be suspended for more than 10 days in a school year, expelled, or if the behavior involved possession of weapons or drugs or resulted in serious bodily injury. On the other hand, though, there is no requirement that a student be facing disciplinary action before an FBA is conducted. I've had schools say, well, he wasn't in trouble. He hadn't gotten in trouble yet, so we didn't do an FBA. Well, there were still behaviors of concern, So you can go ahead and do one prior to, and you really should, to be proactive instead of being reactive. You should be doing it before discipline and days of removal become an issue. The parent or the school can request FBA just as any other evaluation.
Sorry to interrupt you, but that's just something that keeps coming up over and over for us, is who's responsible. Like, I'm coming from districts where that was always the psychologist, but I've been in schools where they think it's just the TOR,
It's really, it's the M team, so it's the multidisciplinary team that conducts an evaluation, because again, an FBA they're done, I know a lot of schools do them informally, but they really are an evaluation, and it needs to be that evaluation team that's doing that. Okay. And it may be that the evaluation team is the psychologist supervising that says, hey, TOR, we want you to collect this data, but it needs to be more than just that one person. Does that make sense? Okay.
Tomorrow afternoon, we have 3 hours on FBAs, BIPs,
Yes,
and
and-
LRE, so luckily
Yes.
we can get into the real nitty-gritty
Nitty-gritty.
then too
That's
as well.
right. And
So,
I'm-
and
that-
this is really
so-
good because obviously you have an interest in it, and so it's perfect that we have that topic tomorrow.
So I'm just whetting your appetite for that. There is more to come. All right. So the BIP is your plan. It's incorporated in the IEP. It identifies the pattern of behavior that impedes the student's learning, and it identifies the purpose or function of that behavior, and that all comes from the FBA. The BIP lists the positive interventions in sports and other strategies. What a good BIP should not do, but what I see it looking like in IEPs, and it makes smoke come out of my ears as a complaint investigator, is that the student will follow all of the school rules and policies related to discipline. That's not individualized, and that's not any different than any other student. That is not, you have put something in the section for BIP, but you've not really done what you need to do. And if that goes to a due process hearing, that's not going to flow as an appropriate BIP. Okay? So you can't just wholesale incorporate your disciplinary rules, your code of conduct, or whatever it is in the BIP and say the student will do this. You've got to individualize what are the positive interventions. You're intervening before the behavior for this student based upon what the FBA has identified as their behaviors of concern. And other strategies to address the behaviors and maximize consistency of implementation across people, across settings. So, does the BIP have to be implemented in the gen ed class? Yes. Does it have to be implemented in music class? Yes. So if the student has access to a hot pass to get to go down and see the counselor when needed, does music teacher have to do that, or can music teacher say, you don't get to leave my class? Nope, that would be a violation if music teacher doesn't implement the BIP across settings. All right, and if applicable, and usually applicable, what are the skills that are to be taught and monitored in an effort to change the behavior? So it's not just being reactive. If the student does this, they're going to be sent home. That's reactive. What are you going to do? What are you going to teach them so that they don't do that behavior in the first place? We want you to be proactive and avoid the behavior that's not desirable versus being reactive to it. Removals, they do occur. School, again, this is just a review. School is not required to provide services to a student with a disability during any of the first 10 days. And again, reminder, removals any part of the day, so even for an hour in the office with no books, no services, that's a day of removal. Short-term removals. If a student is removed more than 10 cumulative instructional days, not 10 in a row, but cumulative. You add them up, all the pieces and parts. The school must determine if a change of placement has occurred. What is a disciplinary change of placement? Disciplinary change of placement occurs automatically if you have more than 10 consecutive days. You don't even have to do decision making. Okay? If it's been that bits and pieces where it wasn't consecutive, but cumulatively there have been more than 10 days, that's when you have to look to see if there's a pattern. And that's where you're looking to see if the student's behavior is substantially similar to behavior in previous incidents. You look at additional factors. This requires you to do some thinking, and a lot of schools have moved to a model where they just say, if it's more than 10, we don't care. We're going to consider it a change of placement. You can't be wrong by implementing that method. If you just have a policy that whenever there are more than 10 days of removal, you're going to consider a change of placement, you'll never go wrong there. And like I said, a lot of schools are moving that direction. But if you go the other way and you look at the behavior and you find that, well, Susie kicked the teacher and was suspended for 5 days. And then Susie went 7 months, and then Susie forgot homework 3 days in a row, and so she was sent to the office, from that gen ed teacher's class, and so she had a day that was considered a day of removal because she spent an hour and a half in the office and didn't have any services. And then Susie does something else that is... Susie was smoking in the bathroom, and so Susie got a 5-day suspension. Oh, 5 plus 5 plus that 1 day in the office, you're at 11. those aren't related. Those are different, incidences. So that might be where the removal is, it's not a pattern, so it wasn't a change of placement for those cases. But again, a lot of schools don't want to make those judgment calls. They just say if it's more than 10, it's going to be a change of placement. But regardless, even if it's not a change of placement, you still have to give services anytime you go beyond 10 days. You may not have to do all the other things that you have to do, but you still have to give. The key is services always at day 11, services at day 11. If the removal is a change of placement, which more often than not usually is, that decision to remove the child, you have to notify the parents, you have to provide the parent with a notice of procedural safeguards. The notice must be provided on the date the school decides to make the removal. A lot of times you're not giving the parent the notice of procedural safeguards. Make sure you give those out. Put that in there because people forget to do that. And you've triggered manifestation determination. Within 10 instructional days of any decision to change the placement for violating disciplinary rules, the CCC must meet to determine whether the student's behavior is a manifestation of the student's disability. Suspension that will result in suspension for more than 10 consecutive days. Again, this is just review. It can be a series of suspensions constituting a pattern. It can be an expulsion, or it can be behavior involving possession of weapons or drugs resulting in serious bodily injury. Those things all need the manifest determination. At the manifest, and I'm going through this really quick, if you get to the manifest and you need technical assistance, call one of us. We'd be happy to give it to you. We would need a full day to do this justice, so I'm going in a nutshell. You have these, but the key is call us if you need technical assistance. The CCC must review all relevant information, including the IEP, teacher observations, and information provided by the parent. So if the parent's telling you, we just had a death in the family, there was just a divorce in the family, Aunt Susie just moved in and it's caused total chaos, those are relevant factors. And if the parent's telling you that, you probably ought to note that in the written notes section of the IEP, because those are relevant factors. Don't discard. You're going to be out of compliance if you don't take those things into consideration. You have to determine whether the behavior was caused by, I want you to put two hands up like this in a V. Exercise. We're going to be kinesthetic. There are two prongs to a manifestation determination. Nope, keep them up there. We're stretching. There are two prongs, okay? So this is the former kindergarten teacher in me that we're going to be kinesthetic, okay? The first prong, right, one hand, okay? This is the one that everybody seems to understand. Put your other hand down. Keep waving this one. All right, you got it. But we're on the first one right now. And that's that the behavior was caused by or had a direct or substantial relationship to the disability. That one makes sense to everybody. People usually do that one. Now, put up the other hand and wave it. And keep waving it, because I want it to get a little uncomfortable. Because this is the one people forget to do, and I don't want you to forget that you had to keep your hand up in the air, okay? Determine whether the behavior was a direct result of the school's failure to implement the BIP. Yeah, Susie did something bad, but Susie wouldn't have done it if you'd followed her BIP. That's a manifestation of the disability. Because you didn't implement the BIP, folks, she did what she did. So there's two prongs to the manifest. So when I get the complaint that the school didn't properly conduct a manifestation, the first thing I'm doing is I'm turning to the written notes section of the IEP, going there day one, looking at an IEP, and I better see two questions in that. I better see question one, was the behavior caused by or have a direct and substantial relationship to the disability? And two, was the behavior a result of the school's failure to implement the IEP? So under that prong two, you're going to document real quickly, what did the school do? The school did three things, and I look at the BIP and it required those three things. The school did all those things, the students still engaged in the behavior, okay? So it wasn't the school's failure to implement the IEP. You've successfully completed, you've fulfilled the two prongs. Okay, sorry, I made you exercise, but hopefully you won't forget there are two prongs to the manifest. All right, if the conduct was a direct result of the school's failure to implement the IEP, the school must take immediate steps to remedy those deficiencies. You're still okay. If you find that the gen ed teacher didn't implement the BIP, it's not great, but you can rectify it if you take these immediate steps, okay? You have to be returned to the student has to be returned to the placement they were removed from unless they've been placed in an IES. You have to provide service. I mean, I'm not going to go into everything, but you need to rectify that. If you find that it was the failure to follow the BIP, that would be a great time to call one of us if you don't know what to do next. And we can walk you through it because it's pretty convoluted. And I know this is higher level, and I keep saying that, but it is tricky. I've worked as a complaint investigator for several years, and I'm just now, the process is just now really starting to make sense to me. So what I can tell you is it's okay to admit it's hard. Manifestation determination is one of those harder things in special ed rules, and we are here for you, and we would be happy to answer any questions that you have to provide technical assistance. Okay? Perfect. Okay. If the behavior is a manifestation, again, you must conduct an FBA and develop a BIP unless you've already done that. And if a BIP has previously been developed, the CCC must look at it. Is it not sufficient? Do we need to review so review and revise? So you may need to do that. But obviously, if there was a BIP, it's not working. If it continues, there can be problems. If you find the conduct was not a manifestation of the student's disability, the CCC has to determine the appropriate services to enable the student to continue to participate, to progress toward meeting the goals, and to receive an FBA and behavior intervention services that are designed to address. What is the underlying theme on all this? What do you have to always provide, whether or not it's a manifestation? Services. Provide services. Review what's going on. If there continue to be problems, even if it's not a manifest, something's going on. So use this time to figure out what's going on, revise, look at whether or not we need to conduct a new FBA. Those are all considerations you should be looking at. And whatever decision making you're engaging in, if you're finding it's not a manifestation, explain your reasoning and why you found that to be true in the written notes. Okay? Because a parent might challenge that. All right? They have the right, and we're going to get to that. Let me go there. If the student's parent disagrees that the student's conduct was not a manifestation, so you say it wasn't a manifestation, the parent says, I think it was. They have the right to request mediation or go to due process hearing. So if they go to a due process hearing and a hearing officer is reviewing why you said it wasn't a manifest, if all you have in the IEP is the behavior was not a manifest and no reasoning, they're not going to agree with you. But if you list your reasoning and you can document and you can explain why you found it wasn't in that written notes, the hearing officer is going to be reluctant to replace his reasoning with your reasoning as long as you have a basis for what you did. And if all you put is just a yes or no, you can't explain why you did, they're probably then that might be problematic. So document, document, document. Use those written notes section to explain why you arrived at the decision that you did, if you're finding it's not a manifestation, because parents are likely to challenge that. All right, while we're talking about discipline, IAES. How many of you have heard of the term IAES? Keep your hand up if you can tell me exactly when an IAES should be used. When can it be used? Don't look, cover your eyes. There are 3 times, I'm sorry, you want to try to do it? No. Okay, there are only 3 times that you can use an IAS. It's when the student has used or sold illegal drugs at school. It's when the student brings a weapon to school, or it's when they've inflicted seriously bodily injury. If they punch a kid in the arm, hard, and it leaves a mark, is that serious bodily injury? Probably not. If they cut the student's arm off, probably serious bodily injury. Okay? If they kick a teacher, is that serious bodily injury? No. Absolutely not. If they kick a teacher and the teacher is hospitalized for 2 days and files a workman's comp claim, is that serious bodily injury? Yeah, you're approximating serious bodily injury there because you can document that. Serious bodily injury is a legal term. It has to be serious. Okay? I mean, it's, yes? Well, the principal has the right to place a student. They don't have to convene a CCC. The principal has the right to place an IES for up to 45 days. So that's their call. But that's a call where you're going to want top-level administrators involved. And that's not a bad time to call if you've got legal counsel for the school, it's not a bad time to call them and have that discussion, because then you can say the school was acting on the advice of counsel. I mean, you've given it some thought. Again, document your process, right? Okay, in some cases it's going to be very clear. If a student stabs another student, well, first of all, they had a weapon, but that's going to be serious bodily injury. Okay, if the student kicks a student, if the student punches a student, that student falls down and hits their head, is knocked unconscious, goes off in an ambulance and spends 2 days because of the concussion in the hospital, that's looking more like serious bodily injury. Punching in the arm, leaving a mark, not so much. Okay, so I'm sorry, it is discretionary. There's case law out there. I'd be happy to share those standards with you if you want to follow up with me. I didn't bring those. Yes?
So for a small charter school, what would be considered an IAES, an example of a setting?
It can be different places. It might be homebound. It might be that they're going to come after school, but it's an interim, alternative educational setting. They're not in the normal class setting. They're somewhere else for up to 45 days because of one of these three things. I'm sorry, it's not. So it's not one specific place. It's just that they've been removed to someplace else, and you don't have to do the whole CCC, and you don't have to conduct the full manifest. You don't have to go through all of that. Well, I mean, you do have to do some of those things, but you can make that decision immediately, and the principal can unilaterally do that on their own if it's triggered by one of those three events. Okay? Good question. All right. Student discipline issues. Obviously, schools must have written discipline rules, and it's a graduated system discipline. Remember that your suspension and removals must comply with also with Indiana code on those. Removal, these are reminders, removal for any part of the day constitutes a day removal, including short-term removals, but not short-term removals pursuant to the IEP, and that's what we discussed earlier. If it's in the BIP, you have some wiggle room. In school, that's in the office, out of class for a half hour, not considered a removal if the student has the opportunity to progress in the gen ed curriculum, receive the services that are specified in the IEP, and participate with non-disabled students. So if you send all their materials down, they don't miss any of their services that day, and they're interacting with peers, then you don't have to consider that a removal. But make sure all those things are provided. So to avoid complaints, communicate with parents. The best line of defense is maintaining good communication. Teachers should regularly remind parents to contact them if there's a problem or concern. When teachers are in doubt, communicate up with your special ed staff, your director, your administrators. And schools, you can use mediation to resolve any dispute. You don't have to wait till the parent files a complaint. We sometimes get a feeling this parent's getting really angry. I hope they don't file a complaint. Proactively say to the parent, you know what, we seem to have some communication issues. We're not reaching agreement on this issue. Would you like to go to mediation? Because the state will pay for it for free. Before it becomes a complaint, you grab the bull by the horns and you suggest mediation. If you want language from me, I'll talk you through that process and I'll help you, give you technical assistance on what to say to that parent during that phone call. Love mediation. I'm going to keep saying that. It can be used to resolve complaints or any disagreement. But both parties have to agree. We need to have a signature from both parties on the request for mediation, because I'm not going to pay for a mediator to come to a meeting where somebody doesn't show up. It's voluntary. If they come and it doesn't go the way you want, you can leave at any time. You don't have to reach an agreement. The mediator is a registered mediator and an attorney in Indiana, paid for by the DOE. So you're getting several $100s worth of free services paid for by us. It's confidential. The only thing that's not confidential is what ends up in the agreement, and then whatever is reduced to writing and signed, that's there. But if you talk about some things that you don't want other people to know about during that meeting, that's okay. That's all confidential, and you can't. Neither party can call in the mediator later into court or anywhere else to talk about what was said. The mediation agreement is legally binding. Mediation is less adversarial. It's less time-consuming. It's less costly for the school. It's way cheaper than going to a due process hearing. It's easier than having a 40-day complaint process. And it's really successful when both parties approach the process with an intent to resolve the issues. But that's where you're having that phone call ahead of time and talking up how good mediation is to the parent, and that you really want to try this because you think it's going to solve your problems. It allows creative problem solving to reach a resolution. Not going to spend a lot of time in due process hearings because I think almost all schools are going to use an attorney if you get to the level that you're at due process hearing, but it can be used to resolve issues related to evaluation, identification, eligibility, services, placement, or reimbursement. Provision of FAPE. Going to a due process hearing is basically like going to court. It's an independent hearing officer instead of a judge. And parties may be represented by counsel or a non-attorney advocate, but most generally speaking, both sides are represented by attorneys, and it's very, very legal. Very hard to do. Parties have a difficult time doing it on their own. Written request, it requires a written request for due process hearing. It can be made by the parent, an 18-year-old student. It can be made by the school. So if you're defending your position or saying, for example, why you don't believe why an evaluation is required, you can go to due process hearing to defend that position. It's limited to things that have occurred within the previous 2 years. I'm talking about timelines, I'm going to back up. Complaints are 1 year. So there's a 1-year statute of limitation for complainable issues. There's 2 years if a parent wants to go to due process hearing. How does a due process hearing work? The parent or school or whomever files, the request is filed. Hearing officer is assigned. We assign them. Then the hearing officer takes over. There's a response or answer from the other party. There's an opportunity for resolution session, which we can do mediation in lieu of resolution session. The hearing's conducted. There's a written decision. That decision has orders if there's a violation, and there's an opportunity for appeal. Well, how do we get there? Same reason you get to a complaint. Differences in educational philosophy, methodology, differences in opinion about what the student needs. Often it's a breakdown in communication. Sometimes it's your personalities. You just got that parent and that teacher that absolutely cannot get along. And that's regrettable if you're going to that. I have talked longer than I should have. One last question.
Oh, okay. Just really quickly. So if somebody asks for due process, can you suggest mediation, or how does that come up if they've skipped that step?
Well, if they file for due process hearing, you're in that process. You can't just. But there's a resolution session. They use mediation in lieu of that, and often the attorneys will get together and say, "Let's just mediate this anyway." I mean, that's how that works. But you can't force them to go to mediation in lieu of that.
Okay.
At that point, does that answer your question?
So it wouldn't be mediation then is off the table, and there can be a resolution session.
There is a resolution session built into the hearings that are requested by parents.
Okay.
Okay?
Yeah.
And so, but a lot of times the parties will opt to use mediation in lieu of that, and then if that mediation or resolution session doesn't resolve it, then you proceed with the hearing.
Got it. Thanks.
Okay? Perfect. Okay.
I probably don't need to see. I need to go back to the beginning when you said when a parent requests an evaluation, does that not start the 50-day clock? They have to. It's that 10 days.
No. The 50 days, so the timeline for evaluation is parent requests an evaluation. The school then has 10 days to respond in writing with a formal notice using Indiana IEPs little form that's fabulous.
Right.
That they are either proposing or refusing to do the evaluation. If you're refusing, you give your reasons why. And then within 10 days, that written notice has to go to the parent. And if it's that you're proposing, so you're going ahead with the evaluation, if you generate that on day 2, you have 10 days. Let's say you generate on day 2, then the parent signs consent 2 days later and gets it to you. It's when that consent comes back in. The signed consent.
So it's 50 days from the signed consent.
There you go. So you got two steps. You got to generate a proposal with the consent.
Right. But if the school takes that 10 days, that actually makes it 60 instructional days that
you
the
could,
school has.
Yes, you could have that long. But it's the 50 days. Good question. The 50 days for evaluation starts at consent. The gist of what Matt said was you do have more than 50 days because you have that time for consent, but you can't be starting early. You don't get to jump start. Don't start the evaluation until you have consent. You could be in violation then because you have to have that consent. My time is up. If you have questions, please don't hesitate to email me or call me. Be proactive instead of reactive. And thank you all, and I hope you have a fabulous rest of your school year.